Generally speaking, if a person is convicted after trial, or even sometimes after a guilty plea, they have the right to appeal that conviction to a higher court. It's important to understand that if it's not part of the record, it's not something that can be appealed. So what is an example of something that's not on the record? The example that often comes up is conversations that you have with your lawyer, advice that your lawyer gives you, strategies about what defenses to pursue, what witnesses to call, whether to testify at the trial. How does one challenge those? Those are challenged by way of what's known as a collateral attack. In the federal system, that's known as a federal habeas petition or a 2255 petition. All the different states have their own procedural mechanisms for bringing those kinds of claims. There are usually two types of claims that can be brought in that kind of proceeding. The first is if there is newly discovered evidence, evidence that would tend to lead a person not to be convicted, and evidence that wasn't known at the time of the trial. It has to be new. That's a rare instance. The other, much more common situation is where a person thinks that their lawyer didn't do a good job for them, that their lawyer gave them bad advice, that their lawyer made decisions that ultimately led to the conviction. That is known as ineffective assistance of counsel. And that is a claim that has to be brought directly to the trial court, and only if the trial court denies it, then you can appeal it to a higher court.